Hello, YouTube. I'm Vince White. I'm an employment attorney, and I have a little something here from friend of the channel, David, today. And I love this. This is wonderful. New York State, as of May 7th of 2022, will require employers to have transparency in their electric monitoring of telephone calls, emails, internet access, and internet usage. Don't know what the difference is. But as of May 7th, 2022, employers are going to need to be transparent when they're monitoring people. Now, this is going to include any employer with a place of business in New York State, regardless of size. So I take that to mean any company that's even got like their little toe in New York State. And if that company then monitors or intercepts employees' telephone calls, emails, or, again, that language, internet access, or usage, they'll have to be transparent about it. There's a notice requirement. They just have to provide notice to their employees upon hiring. So it's going to go in everybody's employment packet, new hire onboarding packet. And they've got to keep a record of that notice. And the employee must acknowledge it in writing or electronically. So that's really important. Those employers are also going to have to post it conspicuously along the office. So your lunchroom is getting uglier. There's more and more notices posted in the lunchroom. It looks like they give specific rules about what can be said in that notice, this and that. So that's useful. It's always nice when they do that. There are a couple of exceptions, and these were odd. The law does not apply to processes that are, 1, designed to manage the type or volume of incoming or outgoing electronic mail or telephone, voicemail, or internet usage. I think that means two things. If you work in a call center and they just track how many calls out you make or how many calls in you handle, that's probably going to be fine and not subject to the notice. Also, I bet you all those apps that track, like, if you have malware, and if your email account is spamming out messages, those are all going to be fine too because it's just tracking volume. 2, not targeted to monitor or intercept the electronic mail or telephone voicemail or internet usage of a particular individual. So I guess if you're not observing the contents of a particular individual's communications, but you're just observing all of them, which seems like it just invalidates the entire law. I don't fully grasp that exception. Or 3, if it's performed solely for the purpose of a computer system maintenance and or protection. Now, an employer found to be in violation of the law will be subject to fines of $500 for the first offense, $1,000 for the second, and $3,000 for the third. And from then on, it's $3,000 for every offense. Here's the key, and this is always really key. So there's no private right of action. No private right of action for this one, okay? Which means the state can fine your employer, but you're not going to see a penny for it. That's really important to know. It also means no attorney's going to help you with this because they can't win you money, so they can't take a percentage of what they can win for you. So, that's real. This was a fascinating article from Shepard Mullen. Thank you, David. And I will post a link to the article by Sean Kirby and Jamie Moelis down below in the link so you can see where this information actually came from because it did not spring forth from my mind. I am not that clever. And thank you, David, for bringing this to my attention. And I hope that you all have a wonderful holiday week. I may or may not make more videos, frankly.